So today we are going to talk about how to manage a project to make your company comply with data privacy. But before we start, just a little bit about myself. As I said before, my name is Marcio Cots. I'm the Chief Operating Officer for GetGlobal International. GetGlobal is a data privacy company. I'm an international data privacy lawyer. Actually, I'm an European data privacy lawyer with more than 20 years of experience and more than 100 data privacy management programs implemented in multinationals and big companies all around the world. Today, we are going to talk about something that at least for me, it's one of the most interesting things about data privacy. Usually, when we talk about data privacy, we divide data privacy into two big major topics. Either you talk about the legal aspect of data privacy, so the obligations, the data subject rights, and things like that. Or you talk about the second major topic, which is management, how you manage a data privacy program. What do you need to identify or even change in a business operation, in a company operation, in order to make this company comply with the data privacy laws. And actually, there is different ways to do that. And most of the data privacy laws, they don't tell you what exactly you need to do to comply with those legal obligations. But nowadays, we have different methods, different ways of managing data privacy programs. Usually, we say that would be a program instead of a project, because under, for example, the PMI standard of managing a project, a program is something bigger than one project, because any data privacy professional knows that there are so many different projects that you need to manage to make a company comply with a data privacy rule, that actually it would be a program instead of a project itself. But anyway, if we try to draw an ideal data privacy management program, we would definitely have to think about actually three major things, such as the legal requirements. So any data privacy law will have different legal requirements, legal obligations. For example, the GDPR requires from you to have a lawful base to process the personal data. So that's a legal obligation that you have to comply with. So we need to try to understand what we are going to have to do in order to comply with this legal obligation. Or even you have all the GDPR's principles that you have to comply with, the principle of minimization, the principle of necessity, the principle of transparency. How would a company be able to comply with those principles? Actually, what would we have to change in the company's operation to be able to comply with those obligations? Or even the CCPA, the California Consumer Privacy Act, you also have a different legal obligations to comply with. It's the same thing. We need to identify what would be considered personal information under the CCPA, and what would be a regular data, for example. So those are what we call legal requirements. So those are the legal obligations that any company, any organization, any data processor or controller will have to comply with. Besides the legal requirements, we have the individual's rights. So all those data privacy laws, they stipulate the individual's right. So, for example, under the CCPA, the California Consumer Privacy Act, the individual's right to have the right to tell you to not sell their personal information. And the company will also have to comply and respect this individual right. So these are pretty much the two major obligations that we'll have to keep in mind and try to be able to change the company's operation to comply with those obligations or even respect the individual's right. But that's what we call data privacy. It's pretty much on how you have to procedure to process the personal data, to use the personal data, complying with the data privacy rule. But we need also to try to have a very strong data privacy protection program implemented in order to be sure that we won't have any problem, any illegal issue related with a data breach or any personal data incident. So the ideal data privacy management program would be a program that would be able to help the company to comply with the legal requirements, to respect the individual's right, and have a pretty strong data protection program in place. Because it doesn't make sense if the company process the personal data complying with the law and there is a data breach, and vice versa. It doesn't make sense if the company has a pretty strong data protection program in place. There is no data breach, but you don't process the data compliant with the data, the data privacy rules. So this is what actually we need to do in order to comply with the data privacy laws. But how are we going to do that? What are our tools? What are our sources that would be help us in order to get to this ideal scenario? Actually, our source and our tools are pretty much these ones. And of course, we won't have time to explain each step of this program in detail, mostly because we wouldn't have enough time to do it. So this is just an overview of how to deal with how to manage a data privacy program, okay? So if you have any questions, feel free to ask those questions. You can use the chat or even the question and answer section of our platform, and we would be happy to answer those questions at the end of our webinar. So what sources do we have? What tools do we have? The first thing that we need to keep in mind is that we need to develop a data privacy policies, actually. We need to have those policies because the policies is pretty much where we are going to stipulate the roles and actually the process that people will have to follow to make the company comply with the legal obligations, the legal requirements, and respect the individual's right, and keep a pretty strong data protection program in place. So the policies are pretty much where the company is going to stipulate what are going to be the corporate procedures, the corporate rules to be followed by the people, by the employees, by the vendors. And it's in the data privacy policies where we are going to first identify the right people, and especially what are their job descriptions, and what roles they are going to play to help the company comply with those data privacy rules. For example, under the GDPR, we need to point who is going to be our DPO, our data privacy officer. We need to describe what's going to be the DPO's role, what it's the DPO's responsibility, what kind of if the DPO is going to have a team, what's going to this team be responsible for? We will the company have a data privacy committee? We might have one. So if there is one group of people who will make part of this committee, we need to stipulate who these people are going to be. Who is going to make part of this data privacy committee? Is it going to be the DPO, the general counsel of the corporation, also the information security head, the CISO, the Chief Information Security Officer? So we need to start to identify what roles are going to be played by each one under the organization, and the privacy policy is going to stipulate the roles to be played by these professionals. Are we going to work with some data privacy professionals in different areas of the company? Would that be good? Or would we just concentrate all data privacy matters in under the DPO? So those things are things that we need to decide, and we need to draw. We need to stipulate in these data privacy policy. Remember that data privacy policy, it changes from company to company, mostly because of two different reasons. Depending on the core business of the company and depending on the size of the company, that changes pretty much on the kind of policy you are going to have, on the kind of data privacy you are going to have. Because, for example, if we are running a data privacy management program in an industry, a B2B kind of business, probably this company doesn't process a large scale of personal data. So this core business, it's not the kind of core business that will have a huge impact by this kind of law, by a data privacy law. But if we are talking about, for example, a B2C, a business to consumer kind of business, regulated, such as healthcare, a hospital, or even a bank, those business, they are going to suffer a big impact by these kind of laws, just because of the kind of business we are talking about. And definitely the size of the company will also will bring some more challenges for us, because if we are talking about a big corporation, of course, that will definitely be a little bit more difficult for us to implement any kind of a data privacy management program. So these two things, basically these two things will define how easy or how difficult it's going to be for you to implement a data privacy management program. And the data privacy policy also will change depending on the core business and depending on the size of the company. So there is no recipe. For example, it wouldn't definitely work if you tried to implement Goldman Sachs data privacy policy in a company as Google or Facebook. Two different core business. They have big size companies, but core business totally different. Or even if you try to use a data privacy policy of a big corporation in a small corporation. So that's why we need to think what kind of policy we would have. And when I mean by what kind of policy we would have, we start by identifying what data privacy roles we would have in this organization. By saying that, the second thing that we need to think about are the process. We need to design and implement the process that will operationalize the policy. And those process we need to be stipulated in the policy as well. So the policy are the documents where you are going to define the people's roles, and we will also define the process that these people will have to follow. For example, under any data privacy law, we recommend any company to run a privacy by design program. So what kind of procedures are we going to follow? Will every area of the company be responsible for requesting the DPO's help to help in a new project? Because we are thinking about a new product or a new service. So will the area be responsible for letting the DPO know that we are working on a new project? What procedure would we have to follow to get the DPO involved in this project and apply the privacy by design 7 principles? Or what procedures would we have to follow if there is any request from an individual under the GDPR or the CCPA? For example, let's say that any data subject has asked the company to delete his or hers personal data. What procedure would we have to follow to comply, to respect these individuals' right? So those procedures are pretty much the procedures that people will have to follow to make the company comply with the legal obligations to respect individuals' rights, or even to keep a very strong data protection program in place. Also, the policy will have to stipulate the procedures and the rules to monitor and maintain the policy. So people will be responsible for being sure, for monitoring the business operation and trying to identify if the people are following the procedures. And how would these people do that? They will have to follow procedures to monitor if the company is following those policies. So the policy is pretty much where we are going to have all these things that are extremely important for any company to comply with any data privacy law. And how do we do that? I think it's quite clear that we need a data privacy policy. It's quite clear what needs to be in this policy, the roles. We need to have the procedures to be followed. We need to have even procedures to monitor if the company is following those procedures. But how do we do that? How do we decide what roles are we are going to have? What kind of professionals are going to be responsible for data privacy, or what kind of procedures we'll have to follow? Well, actually, it depends on the gaps that we are going to identify by running an assessment. So we start by running an assessment, trying to identify what are the gaps. So we're going to do a gap analysis, and pretty much what we're going to do is we are going to compare the business operation, the company's operation, with the law, and see what kind of procedures, what kind of things that we are doing that nowadays is not lawful. It's unlawful, and that's how we start trying to identify what we will have to change in order to change the procedures, or even the people's mindset, or even if we'll have to have a data privacy software that will help us in some to solve some gaps, or even if we'll have to change a contract, for example, and by changing a contract with a vendor, that would be enough to solve the gap. So the first two is pretty much the first step that you guys can see here is to run an assessment. The way we do it is we try to use a data mapping software, but most of you know that data privacy or data mapping softwares, they are not able to do 100% of the job, mostly because those data mapping softwares, they are not able to identify some personal data. For example, if we get the GDPR as an example, under the GDPR, any data privacy is any information related with the person identified or identifiable. So a software would be able to identify personal data of an identified person, because a person who is identified, it's identified by its name, by its social security number, and things like that. Those things, they follow some standards. A name follow a standard. Numbers, they follow some standards. So a data mapping software would be able to identify this kind of data. But the other part of the personal data definition, it means that it's also personal data, any information related with an identifiable person. That depends on the context. So a data mapping software is not able to identify the context, mostly because we would need artificial intelligence in a large scale, or with machine learning, to be sure that this software would be able, depending on the context, to come up with the conclusion that that person would be identifiable. So we use a data mapping software, but besides that, we do a lot of interviews, because by doing those interviews, by interviewing the managers, we are able not even to identify what kind of data they process, but mostly what's the life cycle of the data in the company. So we are able to, by asking the managers, to identify what kind of data they process, why they got that data, what's the purpose for processing that kind of data, if that data would really be necessary for that purpose. Those things you only be able to identify by asking the employees, by asking the managers. So that's why we do both things. We start by addressing one presentation for the company's managers, to engage the managers, and to make sure that they understand how important this project is, mostly because we can put the company in some legal obligations. Liability would be a big risk. So we explain to them what we are doing, why we're doing that, and why that's so important for the corporation. By doing that, when we go to the second step and we start interviewing the managers, they are going to give us the kind of attention we need, and they are going to be able to answer all those questions that we are going to do during the interview. So we have the software data mapping that's going to show us what kind of data the company process. We have the interviews, and by doing that, we are able to identify the gaps. So we are able to identify if the company is processing personal data that the company doesn't need. We are able to identify if we don't have a lawful base, a legal base to process the personal data, or even if we are selling data without being able to do that, or even if we would have to point a DPO, a data privacy officer. So those are some of the gaps that you might be able to identify by running this assessment. By identifying the gaps, you are able to propose to the company what the company would have to change, to adapt, in order to solve those gaps. Very good. The second step would be what we call classification. We classify what's a regular data, what's a personal data or personal information under the CCPA. And we also start classifying or even identifying what would be the best lawful base, the best legal base under the GDPR. So, for example, these data, are we going to process these data under the legitimate interest, or are we going to get the consent, or we are processing this personal data because we are going to execute a contract, or because we need to comply with a legal obligation? So during this step, we start to identify the lawful bases under the GDPR. So we are going to be able to identify if our database has a lawful base to allow us to keep processing that personal data. The third step is pretty much when we are going to adapt the business operation to start complying with the data privacy law. What I mean by adapting, remember that during the first step, we were able to identify all the gaps. And how do we solve those gaps? Well, most of the gaps will be solved either by changing a company's process, or by changing some contract. So the solution is going to be a legal solution because we're talking about a law. Or the solution for the gap would be to implement a data privacy software that would help. For example, let's say that we have a gap because we are not able to process all the requirements from all the people, all individuals, all data subjects. So all these requirements, let's say that we are a really big retail chain, and and we have to process more than, I don't know, 5,000 different requirements from data subjects. Definitely, that's a big gap. So the solution for that gap might be the implementation of a data privacy software that would be able to help us to solve that gap. Or even the solution for the gap might be changing the people's mindset by training one specific area on privacy by design, for example. That would be enough to solve some gap. So the solution for those gaps are pretty much these ones: either changing a process or changing a contract or implementing a software that will help you to comply with the law, or even by changing the people's mindset. So procedures, as I said, we need to identify and create new procedures to make sure that the company will comply with the law. Documents, we need to draft new corporate rules and new disclaimers in new contracts. So regarding documents, most of data privacy management programs, you will have to at least work on the private policy. You will have to work on the corporate private policy, because the private policy is a document that will regulate the relationship between the corporation, the company, and the data subject. But you also need to regulate the relationship between the company and the employees, because you need to tell the employees what they need to do, what procedures they need to follow to help the company comply with the data privacy law. So we will also have to work on the corporate private policy. You also have to work on the relationship between the company and the vendors. So we will also have to work on the contracts to be sure that the processors are going to follow the rules that we are going to stipulate in the contracts. Try to imagine if you are working in a company that has different franchises. You will also have to regulate the relationship between the company and the franchise, because they are going to process personal data, we are going to process personal data, and that's also something that we need to regulate. Same thing with software. We might need to implement new tools to help the company to comply with these new rules. And as I said, we need to train people on the new rules and train them on the new procedures. So that's pretty much what we do during the third step. The fourth step, if we weren't able, for example, to identify any lawful base during the second step, so we don't have any legal base, we are not able to process the data. What we need to decide what we are going to do with that database. Are we going to anonymize the data? Are we going to ask for the consent? Or we are going to think about a legal opinion to process the personal data based on the legitimate interest? So the fourth step is pretty much to solve the problems that we weren't able to solve during the second step. The last step is pretty much training. We need to enable all employees involved directly or indirectly in processing personal data to do it compliant with the law. So we need to train the whole corporation now. We need to tell the people what are the new rules, what are the new procedures. So that's exactly what we do during this step. So at the end, the company would be able to have the policies um, to, and therefore uh, the people who would be responsible for playing some roles in order to help the company comply with the law. We would have all the process to be followed by the people. We would also have the process to monitor if the company is is respecting, is pretty much following those procedures, and that would be how we would comply with the legal requirements, the legal obligations, and respect the individual's rights and the data, and have a data protection program in place. So that's pretty much what we had for today. As I said before, the idea here is just to give you an overview of how to implement a data privacy program. This is just one way. There are different ways to do that. It's, as I said before, it's an overview. So there are different ways to do that. Let me see if you guys have any question here. I would be happy to answer those questions. Let me see. There is one question here. Is there any difference between implementing a program under the GDPR and the CCPA? Yes, I would say that there are a couple of differences here. The GDPR is it's a really data protection kind of data privacy law. So there are many more obligations under the GDPR than you will find under the CCPA. CCPA, there you don't need to have, for example, a lawful base, a legal base. Under the CCPA, most of the data subjects' rights are you won't find in the CCPA the same ones that you will find in the GDPR. So I think that they are different standards, two different standards. So definitely, I would say that a GDPR program would be much more complicated to be implemented compared with a CCPA kind of project. Mostly because, as I said, there are so many different legal obligations in the GDPR that you are not going to find in the CCPA. I would say that CCPA represents something like 25% compared with the kind of work that you have to have to implement a data privacy management program to comply with the GDPR. Okay, let me see if there is any other question here. Have you ever worked on any project in? Let me see if have you worked in any project in the health industry? Yeah, some of them, and it's not easy because we are pretty much working on with sensitive data, and as most of you know, under the GDPR, sensitive data has some restrictions, some stronger restrictions compared with a regular personal data, and usually it's a regulated industry. So definitely it's not easy. It's a kind of a project that requires from you a kind of knowledge very specific for this kind of industry. You need to understand the business process, and not many people understand how a hospital, for example, works. So you need to dive deep in these procedures to do your assessment, to identify the gaps, and then subjects to your client what change they would have to make in order to comply with the law. So it's not an easy thing. It's something quite complicated, but definitely that kind of project is a big challenge. Definitely. There is one more question here. As you spoke about software to control PI, would you like to suggest any software? I can name some softwares, but I wouldn't feel comfortable in saying which one I would prefer. So there are softwares as OneTrust is one of them, a Big ID. There is one from England called Pauki. So those softwares are data privacy management softwares. They might be able to solve some of the gaps, because keep in mind that a software won't be able to solve all your gaps, because some gaps are, as I said before, gaps that you will solve by changing a contract, or even by changing a procedure, or even changing people's mindset, because you need, for example, as I said, to run privacy by design project and apply the 7 principles of privacy by design, and that's something that a software won't be able to do by itself. But those are just some of the softwares that many companies use, but they are not the only ones. There are different ones. Punit has a question here. Great. Your approach is very comprehensive. How long does it need for a company to do this? Yeah. Actually, depending on the core business and on the size of the company, that would change. If it's a small company and the core business, we're not talking a B2C kind of company, that wouldn't take that long. But if we are talking a big corporation, B2C, and a regulated industry, that can even take something like 1.5 years or even 2 years to identify all the gaps, to classify all the data, to identify all lawful bases, to start changing all the documents, to start training people to play their data privacy roles, to implement data privacy software, to get people trained to use the software, to change different procedures, because these kind of management programs, they change the company's culture. And that's not something that you are going to do in 1 month. So if we are talking a big corporation, that might take 1.5 years or even 2 years for you to do that. But you can do that in a shorter time of period. But definitely you would have to have a big team able to address different projects at the same time. One question here: how the information security program and plan interact with the model you presented? That's a very good question. Remember that the ideal data privacy needs to be, if we divide this ideal data privacy management, we would say that we have data privacy and data protection. So data privacy is the way you process the data, but data protection is pretty much information security. And the way you do that, you can do in different ways. But there are 2 different standards that I like most: ISO 27701 and NIST privacy frameworks are information security and privacy standards that might be able to help you, Sergio. So if you are interested, GetGlobal has one online course on demand on ISO 27001 and ISO 27701. And there is one master class. Our instructor, Luciano Ferrari, a very well-known information security professional, he's one of our instructors, and he recorded this master class comparing the ISO 27701 and NIST privacy framework. So that might be a good idea for you to check those. One more question, Keith. One more question here to add to your answer about health info. Entities not in score of CCPA if you are under HIPAA, HIPAA in the US, that's right, such as healthcare provider or health insurance. Yeah, I was mentioning the project that I worked on health, on the health industry in Europe and not in the US. US has a totally different way of regulating personal data. The US doesn't have a comprehensive data privacy legislation. There is no national data privacy or even federal data privacy law. It's more sectorial. So you were right. If we are talking about a health program, data privacy program in the US, then that would be a little bit different, but the program would be pretty much this one. This kind of data privacy management program, you can apply for any kind of data privacy rule, because you need to identify if we are talking about personal data or not. We need to identify the gaps. We need to change procedures to solve the gaps. We need to implement software sometimes. We need to train people. So that's pretty much the same thing.